Hello, everyone. Can you see me? Oh, perfect. So we are going to we are going to start now. I'm going to introduce to our facilitator, who is joining us today. His name is Humberto Cantu Rivera, and he is an associate research at the Research Center in the University of Paris, France. He is studying the doctorate too in this university, and he has studied law in the Autonomous University in Nuevo León. He has worked as an expert in the delegation of Mexico in the intergovernmental working group at the UN to elaborate the Treaty on Human Rights and
Thank you,
business.
Patricia. Thank you,
we
everyone,
can
for being
share,
here. I'm glad to be working in this
later.
occasion with KiteMex to provide this webinar to all of you.
I would
hope
like
it
to
will be useful.
him,
I hope it will be interesting, and I'll
so
try
that
to make it as
he can start. So
succinct
Humberto, can you join
and specific
us?
as possible, so it can be useful in your line of work. Okay, having said that, I would like to just clarify, I did work last year as an expert advisor to the Delegation of Mexico in the first session of the working group on the treaty process to create a binding international instrument on business and human rights. It is a process that is just starting, but well, that was my role last year. I've been working on this topic for the past 7 or 8 years probably, and well, I'm working in different areas and with different actors to, as one of my dear friends, Surya Deva, says, humanize business. So about humanizing business precisely, let's start with some background on how this movement, how this business and human rights agenda has started to develop worldwide in the past 40 years. As you can imagine, it's not a new subject. Probably if you were present at the past webinar, you heard more or less from Elena Villafuerte from Prodesk on how this has developed. I'll be quick on this. I'll just share the few important points on this development to, you know, just to give you some context on how things have moved. First of all, how did this topic appear in the public agenda internationally? There have been several issues, several situations that gave rise to this problem. The first one was the use by South African companies or transnational corporations working in South Africa in the 1960s, the use of apartheid. That was a common practice at the time, and that was widely used by different companies in different sectors, but mostly, as far as I can see in the litigation processes that have started since, in the automotive industry. So, as a result of that, the Security Council started to pay attention to those type of situations to make sure that corporations will not negatively impact on human rights. After that, actually the most known and probably most important situation that gave rise to this discussion was the participation by ITT, an American company, in the Chilean coup d'etat that had place in the 1970s, early 1970s. As a result of this, Salvador Allende, the former Chilean president, asked the United Nations to start working on some sort of international regulation to make sure that corporations will not negatively impact not just human rights, but also political processes, the democratic stability of developing states, and so on and so forth. So these two developments, these two important situations, brought the issue of how corporations have an impact in political, social, and democratic life to the UN forum. This forum was, at the time, still starting to, well, was still developing with the apparition of new states due to the independence processes in Africa and other regions of the world. It was more or less of a club that was expanding. This club was expanding because, well, all of the new states were entering the arena, but they were also calling for new measures so that the democratic international order would become more equitable for everyone, so that everyone would have access and say in how the rules were made, how the rules were developed. So this was another factor. These three factors together led to a call by the Group of 77, the group of mostly developing states and other states, to call for a new international economic order. You can see it here in the presentation. It is the second bullet, the first bullet under the UN Code of Conduct for TNCs. This new international economic order basically meant that developing states or new states, newly independent states, would participate fully in the development of international norms, mostly in the economic arena, but also in other political processes. So the idea was to recreate in some sort, make a refoundation of the rules at the United Nations so that everyone would have a democratic, forum, an equitable presence, and everyone would have the same rights and obligations. This call for a new international economic order gave also rise to an idea to regulate under international law the conduct of transnational corporations. The main focus was at the time, were at the time American companies, obviously, not European companies, which were powerful, but not expanding or not as, how to say this, they were not trying to conquer new markets necessarily. They were trying to serve their own region and to develop economically in their own region without going further, without going, for example, to the Americas, to Asia, or to other continents, Africa, for example. So what happens with this? Between that call for a new international economic order and the requests and the thinking at the time that every country had the right to sovereignty over natural resources, the UN, at the time the Economic and Social Council, decided to set up a commission on transnational corporations after or as a result of a recommendation by a group of eminent personalities. This was the 1970s. This group of personalities issued its report in 72, 74. Well, between those years they worked to develop that report. And in 1974, the UN Commission on Transnational Corporations was set up. It started working the next year in addition to the Center on Transnational Corporations, which was a think tank that would provide with inputs and other recommendations to the Commission, which was a more political body. It was actually formed or integrated by government representatives, so it was in all terms an intergovernmental commission. And so these two organs were supposed to contribute to develop a UN Code of Conduct for transnational corporations. This effort started in 1974. It went until 1992, but it was not the only one. One characteristic of the 1970s and 1980s was precisely that many international organizations, for example, the World Health Organization, the ILO, the OECD, all of them were developing codes of conduct for transnational corporations in their own respective areas of work. 1977 was the year that work actually started in the UN Code of Conduct. As usual in UN processes, everything is developed under a working group. This working group was created inside the Commission on Transnational Corporations, and they worked for more or less 5 years in the main provisions of this project, of this draft Code of Conduct. So by 1982, 1983, the code of conduct was basically completed. There were a few relevant, however, provisions that were not yet finalized, but the working group decided to submit that project, that advanced proposal, to the Commission so that it could take the further steps, the final steps, to make sure that it would be something acceptable to all the states that were participating in that Commission, and then to adopt it. The idea of adopting a code of conduct, which was not a treaty, which was more or less of a soft law provision or a soft law instrument, but however with implementation mechanisms, made it a sort of sui generis instrument. Between what is hard law, hard international law, and soft international law, it was in between. In 1983, the Commission decided to continue working on these relevant provisions that were still lacking, where support or consensus were still lacking, and they finally started making some advances, but it was little by little. And at the same time, something else was appearing in the horizon. The 1980s were the starting point for globalization. As a result of this, many countries were starting to leave their previous positions where they supported the adoption of a code of conduct internationally to regulate the conduct of corporations, and were shifting towards a more neoliberal model, where they needed to attract foreign investment, where they needed to develop economically, and this would be, in their view, necessarily with the help of those very corporations that they were trying to regulate. So by 1988, the process was still going on. It had not advanced much because there was a lot of discontent with the provisions that were still pending. 1998 was one year where they tried to finalize this code of conduct. It was not possible. 1990, another effort, it was not possible. And after 1990, with the different economic climate worldwide, the UN Commission on Transnational Corporations submitted a report that was not very well received by the Secretary General. The Secretary General of the UN at the time, Boutros-Ghali, decided in 1992 and between 1992 and 1994 that no further work should be undertaken on this proposed UN Code of Conduct, and he transferred the two main organs, the two main bodies that were devoted to this task to another section of the UN in Geneva. These two working bodies were based in New York, so they moved them to Geneva, and that marked the end of this initial project. But what is the most relevant thing in this code of conduct, in this project, that is useful for us today? The most important thing was that since 1977, in one of the first meetings of the working group that was in charge of drafting this code of conduct, there was a widespread consensus between all participating members of that working group that human rights and fundamental freedoms were to be respected throughout the operations of transnational corporations. This is a very important thing. I would like you to remember this fact, because we will come back to it after a few slides. So with the death of these projects, the UN was uncertain of how to address the issue, because it was clear that corporations could have a very positive impact in all communities where they worked, or that were surrounding their operations or activities. But it was also clear that several accidents had taken place, had taken a big toll in the number of human lives that were taken by those accidents. And generally that even though they mostly made positive contributions to development, corporations could also have a negative impact. This situation was retained in the agenda of the UN. What happened after the demisal, let's say, of the Code of Conduct? That was 1994, but by 1995, the General Assembly, if I remember correctly, requested the Secretary General to submit a report on the impact of transnational. This pretty much set the path for a new line of work inside the UN, but now focused specifically on human rights. And I'm talking about is obviously the one on the bottom at the bottom of your screen. But what happens in the 1980s? Most of the relevant human rights provisions we now know and that we now use constantly throughout our lines of work were just starting to consolidate. The covenants, the International Human Rights Covenants adopted in 1966 did not enter into force until 10 years later, 1976. And many countries did not actually start ratifying them until the 1980s. This may be a factor that made everyone agree with the fact that corporations should respect human rights. At that time, it was not very clear what what human rights obligations states had, because most of the treaties had not even materialized yet. So that is an issue that will probably or would probably have an impact as the discussion moved forward. Regarding the subcommission, well, as I said, in 1995, the Secretary General submitted one report, 1996 and 1997, two more reports on the impact of TNCs on economic, social, and cultural rights. And in 1998, the Subcommission of Human Rights, which was a subsidiary body to the former Commission on Human Rights, decided to set up a working group on transnational corporations and other business enterprises with regard to human rights. What was the goal of this subcommission? At the beginning, it was clear that corporations needed regulation, international regulation, at least in the field of human rights. And so they decided to try to develop international guidelines for corporate conduct on this field. 1999, they started work actually in this process, and they presented exactly guidelines. Then the next year they presented principles, and by 2002 they had arrived at a point where they knew more or less what they wanted, but they didn't know how to call it. So in 2002, in a session session, let's say, the working group, the members of the working group, decided to fix or to accept the terminology or term norms. Why norms? Because the norms had a more legal sound, a more legal perspective, and were seen as more binding than, for example, principles or guidelines. So the Subcommission on Human Rights decided to develop a taxonomic project. It had basically 6 different areas where they pretty much set up international human rights obligations for businesses. This obviously was not seen as a very wise decision by most of the international community. By that I mean states, or by businesses, which were obviously against regulation on this field at least. And the main characteristic of this project, of these obligations for corporations, of these norms for transnational corporations, was that businesses would now have the same or more or less equivalent obligations as states. If we remember, states' obligations in the field of human rights are basically 3, in accordance with Asbjørn Knight, one of the former members actually of the subcommission, who said that states have a responsibility to protect human rights within their jurisdiction, to respect human rights, that is to not infringe upon them, and finally to fulfill them. That is to make everything possible so that every person can enjoy positively their human rights. The subcommission tried to pretty much take this formula and apply it to corporations. It did state in its first paragraph in the draft project of the norms that the main bearer of the obligations under international human rights law was the state, obviously, but that corporations would have several other tasks to fulfill in order to ensure protection and respect of human rights. Two more important things about this project. The Subcommission of Human Rights used the term sphere of influence. It was very criticized, very controversial, because it basically stated that corporations could have an impact or could have an influence beyond their workplace, which was the most common conception at the time. It could have an impact in the community surrounding them, in their suppliers or supply chains, in government even. So basically what they try to set up with this notion was that corporations could and should develop or use their influence or their leverage on the other relevant actors so that people could be protected, not just people inside the company, but people outside the company as well. And another interesting notion was that of complicity. Complicity was mainly seen at the time in the field of criminal law. Some developments have started to appear in the horizon, mainly in U.S. jurisprudence, U.S. case law. But complicity was one of the factors that also made states and corporations dubious about this project. There were different types of complicity as described by Andrew Clapham and Scott Gervais in one seminal article from around that time. But they were basically three: active complicity, active complicity and silent complicity. The third one was passive complicity, but the silent one was the most relevant, because when corporations, he said, didn't claim that a human rights violation was taking place, just because it benefited them, it meant that they were also complicit in that human rights violation. The norms were not very well received beyond academia and the civil society organizations world. And what happened then, in 2003, they were adopted by the subcommission and they were transferred or presented to the commission for adoption. But after some lobbying by the International Organization of Employers or the International Chamber of Commerce, they were discarded. They were basically discarded by the commission, by its parent body, who said that as a draft project, it had no legal standing, and that the subcommission should not exercise any monitoring function in that regard. So with that, we can see how from the UN Code of Conduct, where there was consensus on the idea of respecting human rights as a responsibility of businesses, to, on the opposite end, much larger responsibility that included duties to protect or to fulfill human rights, we can see a big difference, and we can see how this idea of human rights moved in opposite directions in the different scenarios. This will be very important because it was probably one of the factors that were taken into consideration in more recent efforts. I have another point here, the OECD guidelines for multinational corporations. This, I will only make two quick comments. It was a project that was adopted by developed countries in the 1970s, in 1976 precisely, as a response to the UN Code of Conduct project. This answer to regulatory proposal was basically in a non-regulatory way. It was aimed at making sure that businesses voluntarily, more or less, adopted these guidelines They were not mandatory in any regard, but states did have a mission or an obligation to promote them internationally and with their own multinational corporations and in their territories. The most important was that they covered similar aspects. They all, both codes, the guidelines and the code of conduct, both of them spoke about, for example, non-discrimination. Both of them spoke about consumer protection, environment, taxation, a number of different issues that were treated more or less in the same way. But the difference was that the OECD at the time, with only more or less 30 member states, was a club of developed countries. They pretty much knew what they could achieve and what was politically feasible within that very limited group, as were the UN Code of Conduct and the Group of 77 with the developed states, with the socialist states, was a more heterogeneous group, and therefore consensus was more difficult to achieve. So this background is important because it lets us understand how we arrived to this point in the present era in 2016, where we have a very different outlook on corporate responsibility in the field of human rights. And this takes us to the work of the Special Representative of the Secretary General on Human Rights and Transnational Corporations and Other Business Enterprises. After the norms of the Commission were dismissed by the Commission did request the Office of the High Commissioner for Human Rights to develop a report on the existing normative framework at the time, or existing initiatives on business and human rights. The report, very interesting report and very complete also, did present the different initiatives that existed. We had the Kimberley process, we have the extractive industry and transparency initiative that was just starting, if I'm not mistaken. They had other exercises such as the UN Global Compact. We had these draft UN norms. We had also the OECD guidelines and the ILO tripartite declaration. But all of them were in very different stages of development or of acceptance. So as a result of that report by the High Commissioner, the Commission on Human Rights decided to request the Secretary General to appoint an expert to work on this issue. And so he did. Kofi Annan at the time decided to appoint John Ruggie, professor from Harvard, to clarify and identify corporate responsibilities in the field of human rights. In 2006, he presented his first interim report, only 6 or 7 months after being appointed as special representative. And what he first of all did was dismiss the subcommission's project. He said it will cast a shadow on this mandate and we have to move forward. We need to identify what is going on internationally and how we can address negative impacts by corporations. Two more interesting points that he made in his first leg of the mandate. But first of all, let me just say, in 2005, the mandate was established for 2 years, that is until 2007. In 2006, when the Commission on Human Rights was replaced by the Human Rights Council that is currently in operation, they decided to extend the mandate for 1 further year. So that would give him a 3-year mandate, which is the standard under special procedures of the Human Rights Council. So in 2006, after his first report, he identified that there were three specific points that were relevant for corporations in their own decision-making processes. The first one, and you can read that in John Ruggie's book, Just Business, Human Rights and MNCs. This is the social input, the social aspect of regarding their work. And what does this mean? This means precisely what civil society organizations do in their daily work in relation to business and human rights. he said, what is more important for corporations is the value of their brand. The value of their brand is something that cannot easily recover and that is subject to a lot of different pressures. But the most important one is that which comes from civil society, because if our brand suffers because civil society is, for example, issuing reports on how Nike is building soccer balls in Pakistan with child labor, or if we see, for example, that Apple is developing all its phones with unethical or illegal even working conditions, those type of things can have a very important impact in the image of the corporation, in its brand, and in its value. And that is something that if we as businesses, he said, don't take into consideration, we can suffer the consequences. The other two areas were that affected corporate decision making were the private sector's own agenda. That is, for example, ethical investment funds, corporate boards, all these centers of decision that control how corporations act or that control their funding, and that can have a say on whether a corporation is acting in accordance with the rules or not. And the third one, that is the least, let's say, flexible, was the public sector, because he said, if we have laws and we have regulations, corporations should abide by those laws and by those regulations. If they do not, they can be found guilty of at least law violations, in many cases of human rights violations, and that can lead to other type of problems, including legal liability, which is something many corporations don't want to happen. So those 3 points, how social pressure can have an impact on decision making, how laws and regulations have another impact, and how corporate decisions also impact on that, on those processes, were the 3 main points where John Ruggie found that work needed to be done. He called that polycentric governance. That is the different centers of decision that pretty much regulate or dictate how corporations make their decisions. After having dismissed the subcommission's project and after having found that he would be guided by this polycentric governance, he undertook a number of consultations internationally in all the different continents of the world. And by 2008, he arrived at one specific point, which was a framework that would provide a platform for businesses, states, and victims or civil society to move forward in this field. In 2008, John Ruggie basically taking advantage of the fact that most governments were supporting the way he was conducting his mandate, presented this framework with 3 pillars. The first one is the duty to protect, that is a duty of states. The second pillar, which was the responsibility of corporations to respect human rights, which was, again, a notion that was apparently developing at that time, but as we have already mentioned, was present 30 years earlier. And finally, the third pillar, which is the need for victims to have effective access to remedy. Those 3 pillars, as he described, were interrelated. They were mutually, they affected each other, they affected each other, and they could provide a framework for all the stakeholders to work in the area of business and human rights with clear standards. This project, this framework that he presented, was very well received by the Human Rights Council. It decided to extend its mandate for a further 3 years and to request John Ruggie to make it operational. So far, this was the most important initiative internationally. It was the only one that had received so much support from different states. and allowed everyone to pretty much understand what was the idea of the special representative when presenting this project on how things would have to move forward from that point on. These developments lead us to the adoption of the UN Guiding Principles on Business and Human Rights. This is one document that you have probably heard of if you read the paper that was distributed by Patricia and his team a few weeks ago. It pretty much gives us a clear glimpse of how these principles have an impact on regulatory proposals worldwide. But well, let's take a quick look at how they developed the situation or the discussion further. First of all, as we have already mentioned, the guiding principles are divided in 3 pillars. They have 31 provisions, 31 principles. But the first foundational principle is that the state has a duty to protect human rights. This duty is anchored in international human rights law. The most important or most widely used, at least at the time, UN conventions on human rights do state that, for example, states have the duty to protect not just from their own agents, but also from other non-state actors, such as corporations, but not just corporations. In the case of Latin America, of the Inter-American System of Human Rights, for example, the very first judgment issued by the court had a very clear notion of that state duty to protect, and it actually mentioned it in its first judgment. It said that even though the responsibility may not fall directly upon the state for the actions of third parties, states would still be responsible if they did not work with due diligence. That is, if they did not do everything that was in their power to prevent that damage, that is, by omission. And that state duty to protect pretty much revolves around those two same contexts, omission and due diligence, state due diligence. This means, what does this mean? It means that states should have all the appropriate legal and regulatory structures to make sure that the work and impact of corporations. This means enacting legislation, enacting regulation also, developing public policies aimed at precisely protecting human rights in business operations, and finally, to in those cases that make it to court, to adjudicate those cases in accordance with international human rights law. That first pillar was based on established notions in international human rights law, so it was obviously not controversial in any sense. A second pillar was the corporate responsibility to respect human rights, and this was, at the moment when it was presented in 2008 with the framework, and in 2011 or even 10 actually, because it was presented as a draft document in 2010. But since then, the corporate responsibility to respect was seen as something new, seen as something that did not exist before, at least not as clearly as in this point. And to a certain extent, it is true, because corporations more or less were aware that society expected them to respect human rights within their operations, but they did not know how to identify risks to human rights and how to control them or mitigate them whenever they occurred. So basically, the second pillar, the corporate responsibility to respect, set forth four different processes that corporations needed to undertake in order to respect human rights. The first was to develop a human rights policy that came all the way down from the executive position. The most important position in the company, the CEO, would have to enact or adopt a human rights policy corporate policy that then fell down throughout all the corporate structure to make it authoritative. The second point was that corporations needed to have due diligence mechanisms. What does due diligence mean in the context of corporate activities? All this was a more normal or regularly used concept for them. As we all know, corporations use due diligence whenever they're going through a merger process, an acquisition process, or in any other number of circumstances. But in this case, it meant that corporations needed to identify, mitigate, they needed to prevent, and they needed to undertake any possible measures to ensure that human rights were not affected in their own activities or through their supply chains, for example. And this due diligence, human rights due diligence, indeed was a different process. Basically because corporations were not and still are not used to speaking in human rights language. This makes it more interesting for them, obviously, but more complicated also. Within this corporate human rights due diligence responsibility, corporations needed to also evaluate or assess their impacts on human rights, and that is through different measures that are contained in the different reports presented by John Ruggie to the Human Rights Council. Through the assessment of human rights impacts prior to any project or during any project, corporations can easily identify where their main risks are and prevent them, or in any case mitigate them in order to make sure that victims have access to remedies of different kind of remedies. And finally, John Ruggie said that corporations needed to have mechanisms to make sure that victims could have effective access to remedy. Those mechanisms were not just the typical we know, such as judicial mechanisms, but here we are talking about corporate remedial mechanisms that can establish a platform of dialogue and mediation between potential or actual victims and the business itself. And the third pillar was, as I just mentioned, based on access to remedies, because victims have a very hard time accessing judicial systems, mostly in developed countries. We know that in developing countries where most of these negative impacts take place, courts may not necessarily be independent, may not necessarily be impartial, and that has led many victims to go to other I will gladly share them with you if you're interested in that. But the most important aspect was that John Ruggie said judicial access to remedy is not the only way to go about this. We have also, or we need to have also non-judicial access to remedies, that is in the context of national human rights institutions, for example, or in the context of OECD national contact points, which I will explain briefly afterwards. And finally, to have non-state-based, that is something that is outside of state structure, and non-judicial based mechanisms for access to remedies, which pretty much lead us to alternative dispute resolution mechanisms, mediation, dialogue, conciliation, all of these non-confrontational instruments that can be useful to ensure that a situation does not escalate and does not become a bigger problem if it can be solved at an early stage. So these three pillars, the failure to protect, the corporate responsibility to respect, and the need for access to remedy, were the basis of the UN Guiding Principles on Business and Human Rights, are the basis of the UNGPs. What is the most relevant thing about this, not only that he made such an emphasis on the way that corporations can identify risks and on the need of access to remedy, which were situations that were not being treated that way so far, although some initiatives have taken place in the previous project of the subcommission. But the most important part was that he achieved what no other project had achieved by that time, and that was consensus. Political consensus is a very delicate thing, a very delicate scenario, and John Ruggie was able to build consensus around his proposal. This was not all. He also ensured that there was an unanimous endorsement by the Human Rights Council, which was the first time they used that word, endorsement, in any project that had not been discussed or adopted by states themselves. This situation, this unanimous endorsement by the Human Rights Council, led to the alignment of other international instruments and to the consolidation of an international ecosystem on corporate responsibility. I will go to this point in a couple of minutes, but I just wanted to mention that this consensus, this endorsement, it basically, in the opinion of several authors, including me, means that as an authoritative platform, the UN Guiding Principles can probably become, in the medium term, customary rule of international law, because it has the state support, it has the recognition of them as a valid norm under international law, even if a soft law norm. And also because many states are starting to adopt measures to put them into motion, to implement them. And this means, or this is equivalent to state practice. While of course we need to wait some more time before we can actually start considering that the UN Guiding Principles, or at least their 3 pillars, have become part of customary law, they are on the way to become that at the moment. About the alignment of international instruments, and I will have to go quickly because I know our time is moving fast. We have now an international ecosystem. The UN Guiding Principles were the basis for reform of the OECD guidelines for multinational corporations. They were also the basis for the adoption of ISO 26000, which is on social responsibility. And they are the basis for other intergovernmental or regional developments, such as in the case of the European Union or the Organization of American States, in addition to Asian or even the African Union. Some of these organizations have started to work with the guiding principles, have adopted them and introduced them in their practice, in their political discussions and in their processes. And this leads us to the belief that as of now, these UN Guiding Principles have become the basis, the platform for an international ecosystem on corporate responsibility. And precisely about those regional developments, what have we seen so far? In the case of the EU, there has been a lot of Communication 681/2011 by the EU Commission that basically set forth the different obligations that member states of the EU had to implement these guiding principles. They said, for example, that states should develop national action plans, which is an important notion. I will ask you to retain it for later. They asked them to develop also some guidance for specific industrial sectors, to have a report, develop a report on the implementation of the UNGPs in the EU, and a couple more points that I will not touch at the moment. They are important, but not very, very relevant, because they're not so visible yet. The Council of the European Union adopted the strategic framework and action plan. The first one was in 2012 and 2015. The second one that is currently in force from 2015 to 2019. And that strategic framework, although is not based on the UN guiding principles solely or exclusively, it has a focus on that, and it makes operational the different initiatives that were included in the Commission's communication in 2011. The most important one so far has been, or the most important one has been the call for the development of national action plans. So far, 9 states in the EU, 9 of the 27, have developed national action plans. There are several more that are still in different development phases. 2 of those 9 that have been developed have not been formally adopted by the different ministries, so we have 7 that have been effectively adopted, and work continues in this area. In the case of the Organization of American States, which is the one I'm most familiar with, besides the EU case, the first meeting on this topic on business and human rights took place in January 2015. It was basically intended to disseminate good practices by relevant states. There has not been a follow-up to that meeting. There was one small meeting between the Latin American member of the working group in last summer in 2015, and several missions in the OAS, several state missions. But nothing further in that area, nothing from a political perspective. In the case of the Inter-American Commission of Human Rights, the Economic, Social, and Cultural Rights Unit that is based in Washington, D.C., began consideration of this topic to include it within its work stream. They did issue a few weeks ago a report on extractive industries, which makes important references to the UN guiding principles. These have been the most important developments so far. In the case of the Inter-American Commission, they have participated in the last 2 annual forums of the UN on business and human rights, and they are expected to continue working and promoting the use of this initiative developed by John Ruggie. The case of the Inter-American Court of Human Rights is special, and to here I will devote maybe 2 or 3 minutes. And it's special because the Inter-American Court is a very flexible system. It has a very flexible system. It is a very flexible court in regards to the use of different sources for interpretation of alleged human rights violations. They usually make reference to different UN instruments, including general comments by UN treaty bodies, to reports by UN special procedure mandate holders, or to other conventions or agreements or instruments, not just from the universal system, but also from the European Convention of Human Rights and its resolutions, or its judgments, to the African system of human rights. So they have a very interesting and dynamic dialogue with other human rights systems. So a couple of years ago, I was writing about precisely this situation, and I thought that the Inter-American Court of Human Rights was in the best position to introduce these guiding principles, and the introduction of the guiding principles within its jurisprudence, within its case law, would give it an enhanced value, an enhanced position as a binding instrument of international human rights law. Why? Because normally when any instrument comes into the corpus juris of regional human rights system, in this case of the Inter-American Court of Human Rights, it becomes mandatory for its member states at least to give them or consider them as guiding criteria. This happened recently. It hadn't happened before, but in November 25, 2015, there was the first example of the use of the UN Guiding Principles in regional jurisprudence, regional human rights case law worldwide. It was the first court to actually make reference to these standards developed by Jen Brugge, and it was in the Kalinia and Lakono peoples versus Suriname. It was decided in November 2015. It didn't appear publicly until February, if I'm not mistaken, of this year. But it basically meant that now the UN Guiding Principles have entered the realm or the corpus juris of the Inter-American System of Human Rights, and that will make states have to develop a different normative regulatory frameworks in this field to make sure that they comply with their obligations under the regional jurisprudence and under international human rights law. What has been going on at the UN? Several other initiatives. The first one was precisely the UN Working Group on Business and Human Rights. This working group was established after the adoption of the UN Guiding Principles. They started working in November 2011. They have issued different reports on national action plans, which is actually the basis for the current development of NAPs using the Guiding Principles. There was a first report on indigenous people's rights on measuring business and human rights. That is how corporations actually measure their implementation efforts and how they can track them. And two that are coming in the following months. The first one will be probably on supply chains. They have to submit one report annually to the General Assembly and one other to the Human Rights Council. So the two that will be presented this year are on the supply chains, and that is how corporations track human rights, respect for human rights in their own value chains. And the second one will be on state-owned enterprises. That is, all those enterprises where the state is at least a partial owner. In the case of Latin America, this is very common in the petroleum area, in the oil area. We have many different companies that are owned by the state, such as Petrobras, for example, in the case of Brazil, Pemex in the case of Mexico, PDVSA in Venezuela, and a few other in Ecuador, in Colombia, for example, and in other countries also. The working group has also had, besides the task of reporting to those two groups, to those two bodies, the General Assembly and the Human Rights Council, the task of disseminating the guiding principles, and they have done this through different country visits, different annual forums on business and human rights. We have had 4 so far. This year will be the 5th. And through the development of regional forums. They started in 2013 in Latin America. It took place in Colombia. 2014, if I'm not mistaken, took place in Addis Ababa in Africa. And 2016 in Asia, just last week actually, they had a regional forum on business and human rights. These are intended to identify what are the main challenges in those regions, how dissemination is going on, how widespread the knowledge is about the guiding principles. And well, they are important and interesting efforts because they allow the working group to connect with local or domestic stakeholders. And finally, and this is important for all of you working on civil society organizations, the working group has, since at least 2012, started to receive communications. Communications are, probably you're aware with them, but I will explain them briefly anyway. Communications are procedures that are presented, for example, complaints presented before special procedures mandate holders, so that they can, where alleged victims or victims describe alleged human rights violations involving governments or in this case corporations, with the idea that the working group communicates those allegations to the state, so that the state can inform the working group how it is acting to make sure that human rights are respected in the area of that particular mandate. It started in 2012. It has worked more or less so far. They had a 50% rate of response, but they are an interesting mechanism. It has not been very used, so it can be important at least to shed light from a high level at the state on alleged human rights violations that are taking place on the ground that are in many cases not visible to the higher level authorities in any given state. This is what has been going on so far with the UN Working Group that is tasked with disseminating the guiding principles. But in 2013, an idea by the Ecuadorian delegation was floated around in the Human Rights Council session. The idea was that the guiding principles were a good starting point, but they were not binding. They are not binding, and that thus states and businesses and victims need to have a binding instrument, a binding international instrument, to make sure that corporations have effective hard law international obligations, and that states also have obligations to make sure that corporations respect human rights. The state of Ecuador filed a motion at the Human Rights Council at the 26th session. It was adopted. It was intended to create an intergovernmental working group to develop or draft a legally binding international instrument on business and human rights to regulate corporate activity. This was adopted under Resolution 26/9, and the first session took place, as I mentioned before, in July 2015. That was the session where I advised the government of Mexico, and there were several situations that were discussed. The first two sessions will be exclusively devoted to analyzing the principles and elements that should be present in an eventual or a future binding instrument. There was a lot of focus on jurisdiction. There was a lot of focus on how corporations are acting, how states should be acting to prevent or to regulate effectively businesses. And some of the ideas that were floated around in that first session was the concept of their direct responsibility. Many academics, many of the experts that were present at the session to clarify those elements that should be present in the treaty said that there was no limit, no international law limits to establish direct responsibility for corporations. That is true. There is no limit. The states are the ones who put the limit, who set forth the limits on where responsibility starts and ends. However, it is doubtful that direct responsibility is an avenue that can work, at least politically, but also practically, because establishing direct responsibility would mean that they would need a body, a monitoring body, to make sure that to address those allegations of responsibility by corporations. But imagine what would happen if we have such a body. If at the moment we have 195 states around the world, and even with those states, most human rights bodies cannot fully comply with their missions because they have so much work. If we multiply those 195 states by thousands of corporations, the task would be particular work. We could think, for example, of the idea of the possibility of establishing a clear obligation for states to effectively regulate corporate activity and their impacts on human rights within the jurisdiction. That is something that is more that is closer to the classical formula of international human rights law that could eventually be acceptable for states, or at least for most of them, and that can actually make the international system only a subsidiary mechanism, which is how it is anyway intended to work. A second point was extraterritoriality. This was a very interesting notion. It basically means when corporations or other, where corporations can be subjected to the jurisdiction of a country that is not theirs, or where the action did not take place. This is another issue that will be there, basically as a result of two cases, of two sets of cases. The first one of the case law before the U.S. Supreme Court that has been recently oriented towards the negative, that is towards not letting its forum be used for extraterritorial claims. Other states are starting to work on that. For example, the Netherlands have different cases with extraterritorial reach. The UK also has some cases. France has had some cases. And well, some other countries are starting to work on this too. Basically, the main two topics that were discussed in the first session were the width and the depth of a proposed instrument. The width, that is, how many human rights do we want to cover with this instrument? Can we cover all human rights, even human rights that may not have yet developed internationally? Or should we cover just some of the rights that can be politically acceptable and that are actually relevant because they constitute great crimes under international law? Here we're talking about crimes against humanity, war crimes, ethnic cleansing, genocide. Whenever corporations can have a role in these situations, those are the most urgent ones. Those are the ones we should regulate. The thing is, corporations, they do have a role in those, but the regular impacts of their work is not actually in those great crimes. The regular impact is in precisely the human rights to water, for example, to sanitation, to food, to the environment, to health, to education, to the right to work and the different working conditions. Those are the areas where most impacts are. Despite the fact that, for example, mining companies can affect other type of rights, such as even the right to life, the right to physical integrity, where we can see more and where we don't have enough focus yet is precisely on economic, social, and cultural rights. And finally, the depth. The depth means if responsibility should only be ascertained upon the parent company or the parent company in a group of companies, or if we should go all the way to the supply chain. And that means but in vice versa, if the weakest link in the supply chain, the lower tiers of suppliers, can actually engage the responsibility of the parent company for their actions. Those are the two main topics that are being discussed, that will be discussed in the second session this October. And well, the truth is this project of a treaty will probably not consolidate in the next 5 years, to say the least. The Ecuadorian idea was that the project would take at least 10 years. So, well, it will be a work in progress. The most important part will be that states engage in good faith in the negotiations, and that civil society organizations can actually work with those states to make them see what the biggest challenges are. We have also some other developments in the UN. That is the inclusion of this topic of this instrument, the UN Guiding Principles, in other thematic areas. We have them, for example, in the climate change arena. With the Paris Accords, this has been one of the topics where the special rapporteur on the human rights to the environment has insisted a lot upon. John Knox, he has actually issued a report on climate change and human rights where he identifies the role of corporations. We have also the Sustainable Development Goals that were adopted last year, and this is a very important point too, because corporations, it is recognized they are important partners to obtain or to succeed in the implementation of the SDGs. However, and this is one aspect I would like to make a brief comment. Within a political agenda, policy objective, perhaps can make people think that they are not entitled to that states have to work to make sure that people have access to them. But states already had an obligation about many of those goals since at least 1966 when the covenants were adopted, since at least 1976 when they entered into force. So that is something that needs to be taken into consideration. Yes, they need to have a bigger effort, make more efforts to make sure that the SDGs become a reality, but that doesn't take away from the fact that they are human rights that everyone is entitled to, and that those governments have already agreed to protect and to fulfill. And finally, on the UN Guiding Principles have been included already in the work of the contemporary forms of slavery. That is a mandate of the Human Rights Council, that is a special rapporteur. And she actually issued a couple of reports, one last year on supply chains and the way that corporations tend to hide their responsibility through multiple and complex corporate structures, and how they have to work to make sure that those corporate structures do not hide from plain sight the fact that slave labor may be used or forced labor may be used. She also just released a press report after a visit to one, if I'm not mistaken, to one of the Latin American countries. It was released, I think, yesterday, and she identifies precisely that this issue, the issue of forms of slavery, has to be taken into account in the work, not just of CSOs, but also of states and corporations. And finally, what is the role for CSOs? Obviously, well, as you can see, I'm not precisely from a civil society organization at the moment. I have worked for one of them in the past. I'm more or less acquainted with the role and the way they work. But what is the main role that CSOs should have in this field? Of course, filing complaints is the first place, and working with victims. CSOs tend, at least in developing countries, tend to have an important impact on the respect for the rights of victims. In many cases, CSOs or NGOs are not respected as they should be. Their rights are also not respected as they should be. But those two activities that you develop is, well, both of them are very important for not just the victims, not just their rights, but for the democratic order within a given state. Another important point on this, and in this I'm coming closer to the UNGPs, is to share your experience and your input with businesses. Businesses, in many cases, are not as receptive as you can be. They don't necessarily have training on human rights issues as you normally do, or experience with human rights issues as you normally do. And if in let's say good spirits, the idea of collaboration is important. Businesses, if they can see an opportunity to not be attacked, but actually to be criticized constructively, in many cases are open enough to dialogue, at least. And that is important, because without dialogue, both civil society organizations, states and businesses cannot work together in this field. So the idea is to actually engage proactively with them, with businesses and governments, to advance this agenda, to advance this idea of humanizing business, of inserting human rights within corporate activities. And that is a role that civil society organizations can actually play very well. Finally, the idea behind this collaborative approach is to add value. to add value not just to your own brand, because at the end of the day, we know that every CSO is fighting for its own spotlight, for its own niche, but to add value to society, to add value to the way things are developed, to the way things work, and basically to the way human rights are protected and respected. And to add value, to share this value that you have, it is important that the actions of CSOs are mainly propositive. Criticism is necessary, very, very, very necessary for all of the different actors involved, but if it is paired with solutions, with propositions, that can lead the way for true change. It is very easy to just go forward or appear before, for example, at the UN Annual Forum on Business and Human Rights and criticize business. But if in a different setting, in a different scenario, we can actually work together so that CSOs can share their knowledge and that businesses can receive it and try to work together with CSOs to implement it and to track it, there we can find the added value, and there we can find a reason to continue working in this specific field. I noticed that there were some questions going through the forum, through the chat. I will try to answer them. But as far as the presentation goes, this is where I'll stop. I hope it has been useful for you. I hope it will be and was interesting. And I thank you for your attention. Okay, let me.
Thank you so much for sharing your knowledge. And I think it is a good moment for attending to the questions and comments of the participants. So,
Yeah, let me see, because I saw there was one very early on. It was something about the energetic reform.
Thank you so much for sharing your experience and knowledge. And I think it is a good moment for attending to the questions and comments of the participants.
Well, since it is not a question, I think I can just make a quick comment about that. There is
who are here with us, thank you also for your attention.
I see
so
actually
we would like to
Robertson
open
made
a
another
space for your
question.
comments and
Is Mexico
questions.
officially considering an app at this
If you
time?
can share those in the chat and we will
actually,
read them. Right now we can start with those
I requested
that
access to
are
public information
written by Scott Robinson. Thank you so much for your questions, Scott.
They told me at that
maybe
moment that there was nothing going on business and human rights. However, since September last year, a working group, interministerial working group was set up. It is led by the Ministry of the Interior. They had their first meeting then, a second meeting.
That it needs to happen soon.
In February,
given the procedures stated by the energetic reform
in November last year,
especially in mining
the head
and
of the public
energy.
policy, human rights public policy office at the Ministry of the Interior, actually announced the development of an app in Mexico in the coming year, that is in 2016. I became a member of the working group for the third session. At the third session, I can say that different ministries and different offices, mainly from government, from federal government, were present. Other actors, civil society organizations were present. They are actually leading the national baseline assessment at the moment. That is the evaluation, the assessment of how the situation is in legislation and regulation in relation to business and human rights. The expectation is to have an app by the end of this year. Most of us are not entirely convinced. We think that it would be better to wait until next year. However, the thing is, with the coming, with the next presidential election starting actually next year, it may be shadowed. This development may be shadowed by that. But yes, Mexico is at the time considering an app. We are waiting for the NBA, the National Baseline Assessment, to start analyzing the different ways forward. I have participated in that session. I will continue to participate in that. And the idea is to have something that is not just a public policy. We know public policies have are linked or are intertwined to a political life. That is, they are how to say this, reduced to a political cycle. They don't go further beyond that political cycle. If this NAP is adopted, the idea would be to have it supplemented by legislation in order to ensure that it outlives this presidential term in 2018. If it doesn't, then we can clearly expect this national program on human rights and business to maybe disappear or have a lesser role in the next administration, the next government. But the idea is to develop the NAP. The idea is to work together. Government will not be doing it on its own. It is working closely with the Danish Institute of Human Rights. It is working close with PODES, which is the NGO that is leading the charge on this field, and it is receiving input from UNICEF, from the UN, the Office of the High Commissioner for Human Rights, and several other actors. So we can safely say that it is an inclusive process. It is a process that many of us expect to move forward, and well, we hope that we can to achieve the best results that can be measurable and that can be useful, not just for the state, but also for victims. And then I see another question. Can you request this to happen to Mexican authorities today? I don't understand what you mean by this. The NAP, okay. Mm-hmm. I'm sorry, I didn't fully understand the question. Was there? Sorry. I didn't. I couldn't listen to the question correctly. I'm sorry. Can you repeat it, Patricia?
I think he means the NAP.
Okay.
But I think maybe since you explained about it right now, maybe you can tell us about
I get it now.
if you think that if other NGOs need to request it, because I know there's like this working group already, but maybe there are not enough NGOs or citizens.
And there is actually a focal group where other NGOs are working in this field. The one with the most expertise is clearly PODES. PODES have had some experience and they are working very well in this field. But the truth is, if this is not a government commitment, it will not succeed. If governments don't take the lead on developing these public policies, as much as NGOs want to push, it will not have any effect. The advantage here is that Ricardo Sepúlveda, the head of the Public Policy Human Rights Department, is convinced of this. The person actually in charge of business and human rights at the Ministry of Interior is also someone with knowledge, with practice, although from the private sector, but she is aware of the risks, aware of the necessities, and those two things are very important. Also, the pressure from external actors, externals, and by that I mean external to Mexico, is also an important factor that is weighing in this process. Dante Peche, the Latin American member of the Working Group on Business and Human Rights of the UN Working Group, he is in constant communication with the Mexican government, with the different ministries. They have actually announced a visit to Mexico August or early September to review how business and human rights developments are taking place in the country. Having said that, I think and actively participate in the development of this National Action Plan on Business and Human Rights. But it is not the role, in my opinion, to do as much as they are doing. It should be led by the government. It is very welcome that, for example, someone or some group as Poder, who have a lot of experience, a lot of contact with other CSO partners such as ICAR in the US or the Danish Institute in Denmark, they are working on this. But other than that, I could not expect them to have any major or bigger role to play in this. It would not be a government-owned project, and if it is not government-owned, if they are not convinced about this, it is unlikely that they will gather sufficient political commitment to make this not a reality. And I see another question by Scott Robinson, or a comment on the wind farms. The truth of the matter is, if we have, well, this is not a matter necessarily for public policy, because what does public policy do? It coordinates or synchronizes the activities of government in any specific area or in any specific field. We have, for example, a public policy on human rights, which sets forth what the administration, what the public officials in the different ministries and the different offices should do to ensure that they comply with their human rights obligations. But this not necessarily mean a change in the way that things actually work in practice. It should mean a change in the way public officials do it, but not necessarily the rest of the actors. So if the problem, in my opinion, is not there, the problem, in my opinion, is in the area of legislation or regulation. If legislation or regulation is incomplete or does not completely address or fully address the issues that are happening in any given domain, in this case the wind farms, but for example in the mining sector or in other areas, then what we see is that the state is not actually fulfilling its role of regulating companies. But let's think about something else too. If we are working in the field of human rights, and we are thinking here about regulating the corporate conduct and its impact on human rights, what do we look for? Do we look for all the permits, for example, in the case of the wind farms, to be revoked? Or do we look for the permits to be obtained in compliance with all national laws and regulations and international human rights standards. Those are different things, and if they comply with international human rights standards and national and local regulations or legislation, then there would be no sense in denying them the right to do that. We have to think also that, as it has been said by the Grand Chamber of the European Court of Human Rights in many occasions, we cannot subject economic developments or social developments, or both of them, to an issue of human rights. I'm not sure if the last parts I mentioned, if you had time to hear it, but what I was saying is that the European Court of Human Rights has, in many occasions, said that social and economic development cannot be subjected to the rights of a small group of people. And that is something that needs to be taken into consideration. That is something that needs to be interpreted, not just by the government, also by courts, in order to find a clear solution. But that is not something that we can think of to be applicable in every case.
Hi,
So
Humberto.
basically,
I think it's not more
yes,
questions.
the government has impact that they may generate,
Well,
but we cannot expect
I think Patricia has issues of
to
connection.
subject
So,
social
I
and
think
economic
it's not
development
more questions.
that will benefit
We can terminate this
a larger
webinar.
part of the
And
population
thank you
to
for
the
your
rights of
presentation.
a given minority in specific cases.
Thank you.
I'm not sure if there are any other questions. Okay. Thank you very much. I hope to be in touch soon.